NACDL is the association of the nation's criminal defense bar.
Litigating now pisses me off. You know, it's just really bad for my blood pressure and my belief in the Constitution. And Scott, I gotta tell you, I haven't met you, but you did a hell of a job. I believe every word this man says, and I'll hire you in a minute, okay? I kind of left active capital litigation in 2004 after about 28 years being a capital litigator. And then I worked more on training, and I did an exoneration case, and I did a couple 35Cs where post-conviction. I got caught up in a big mess with the Saudi government. And then I came back with Tammy. We came back to the public defender system because we were almost at the point of getting abolition in Colorado, and then it fell apart. And they've got a couple capital cases, so I'm now a temporary attorney in the public defender system in Colorado. So I'm going to get the $99 discount. I'm going to encourage you, but I did sign up for Clear, so I don't know where the finances are going. But Clear is great. You just walk right in. All right, so I'm going to talk to you a little bit about how we've always done it in Colorado. You know, how we always approach a murder case. Because what Scott tell you is right. You know, when I moved to post-conviction, and I'd go back and start tearing these cases down, I was like realizing, you know, why am I doing this from the back end? You know, it's easier to win a death case if you just complain at the beginning, you know? And I have made a living out of being the biggest asshole in the courtroom, all right? Giant asshole. I was called an asshole by a juror in the middle of a voir dire within 15 minutes of voir dire, and that worked out really well, because a lot of people agreed and they had to go home. So, you know, the whole thing is, you know, I like to start fast and start hard. And mainly because I just want them to go pick on somebody else, the get along gang, all right? And as I'm looking at the judges we had back in the late 70s and the early 80s, they were just better people. You know, they actually believed in the Constitution and the rule, and I think they had a little more integrity about being a judge, you know. So are any ex-judges in the room here? Thanks. So you probably know this joke. Why do judges carry turds in their wallet? Positive ID. You know, so at any rate, not you though. But anyway, so as it goes, you know, they've kind of gone away. And they were terrible back in the day. You know, they were just terrible, especially in capital cases, because the fear of not getting, I mean, they don't do capital cases to lose them. I mean, you know, come on. That's not what we're here for. You know, we're here to look all solemn and, you know, process the black man and render the verdict. Didn't want to do it, kind of Judge Smales, you know, gave a 17-year-old boy the death penalty, didn't want to do it, felt he owed it to him. You know, so that kind of stuff, you know, that's what it's all about. And, you know, so we decided, well, we're not going to be friends with anybody. It just doesn't work for us, you know? It's just, you know, they're the same people. You know, they're like the Republican Party. You know, they don't care. You know, the evangelicals don't care about what's going on up there. I mean, as long as they win, and I agree 1,000%, it's all about winning. In capital litigation, they're the same people. We don't need to change, okay? But, you know, and the problem is we're changing, and we're just becoming kind of milquetoasty. And then as I'm now back onto a capital case and looking at what's going on, I always had a belief that that every case I ever tried, I only got about, the beginning I got about 35% of the discovery. Because, you know, they're not going to give you the story of why you don't give the death penalty. Why would they turn that over to me? Why would they turn anything over to me of why I shouldn't get the death penalty, why there shouldn't be a lesser penalty or a lesser charge? They're just not going to do it. You know, and so then I begin to fight, and then I realize, well, maybe I got about 80 or 90% of the discovery. I don't believe I've ever got 100% of actual discovery, police reports, cop interaction, jail informants, snitches, Brady material, and other witness stuff. I've never got it. And then I come back and I'm doing this cop killing case out in Adams County, a home of the prolific liar and cover-up. And I'm going to tell you what now, Scott, they are now taping us in their interview rooms. I mean, when we go to look at evidence, we find out that they're actually monitoring us in the interview room. You know, now you can get all worked up, or you can just start tearing it apart and litigating it, which is what Scott recommends and what I recommend. And so this little thing I'm doing right now is kind of how you walk into a capital case in my mind, which is I'm going to ask for everything. I'm going to push for everything. I'm going to try and spread as big a net as possible. But I'm going to constitutionalize it because I really don't care about local rules or what the judge thinks or what the DA thinks or how it's been done in Boulder County or how it's been done in Adams County or how it's been done in Colorado Springs. I don't care how they've done it. You know, I care about discovery and production and the rules. And I'm very good about reading all the rules of discovery. I know them by heart because they like to come up and they cliche litigate. You know, well, Judge, he's on a fishing expedition. You know, oh, that's a winner. That's right, granted or denied. You know, so you get your little cliches going backwards. No, I'm on a catching expedition. You got to do all that kind of crazy crap. But in reality, they just try and divert you out on cliches and divert you out and just make you go away. You know, my favorite is we know what discovery is. And so then I turn that, once they say that to me, well then everything they do is purposeful. Once they say, we know our rules, we know our obligation of discovery, once they make that allegation, then from now on, it's, well, you said that, then any kind of violation or non-turnover has to be purposeful, has to be intentional, and then I move to recuse you. And I grieve with you. You know, I've never had a death case where I ended up grieving somebody in it at the end because I'm a sore winner, okay? So, you know, that's kind of how the whole thing works. So let's go on here with my little 100 days presentation. And I'll give the presentation till such time as somebody tells me to stop and then I'll leave. Okay? Normal deal. All right. I have a button here. And I'm going to push that one. Okay. Can you see that up there? All right. You know, as I walk into a case, you got a homicide. Most cases in Colorado, it's something really bad because you know, they're just not trying to get the death penalty a lot in Colorado. So they got to really pick bad, right? And usually bad means mentally ill because people like to murder on a high scale. You know, they like to make a huge production of it. Kind of like Tammy's case, right? Mr. Holmes. It was, you know, a big deal, right? You know, it's something very big. So I've got to stabilize the client and the family. I've got to get them in control. So, you know, I'm kind of CEOing the litigation. And by no means do I think I'm the most important person in any capital case. No, you know, the case is not about me. The case is about my client. So I never try and interpret, you know, geez, how am I feeling about how I'm in the case? Because that's called losing, you know? That's called pilot error. You're on the way to lose if you start worrying about how I look in the case and am I okay in the case and how's everybody else in the case? Am I getting enough press in the case? No way. It's just a loser's lament. But so anyway, I'm going to try and stabilize the family and the client. I got to get quickly out to them. So I take whoever it is, usually not me, whoever it is to interact with the family and the client to get them calm down, not talking to the prosecution, not talking to the agents of the prosecution who are coming out and pretending like they're just trying to find out what's going on because we've got this big decision to make. Well, you know what's going to go on. You know, they're going to try and kill your client, and they're trying to use the family. And when we go out and we tell them, well, they're coming out to talk to you, to enlist you into helping to kill your person. And you don't have to talk to them. You don't have to cooperate with anybody who wants to kill your sister, cousin, brother, father, mother, all right? You don't have to. And we'll write it on a little piece of paper and tell them and give it to them and say, no, we don't want to talk to you or help you to try and kill our person. I got to gain control of discovery, which is pretty much what I'm pretty good at, being a discovery lawyer, because that's really what I am. I'm a discovery lawyer. And I agree with everything Scott says. I litigate everything, and I cast a net because I want somebody to lie to me. I'm looking for somebody to lie to me. I'm looking for somebody to, all of a sudden, like, it should be normal. They should be giving this up, and all of a sudden they're not giving it up. You know, it's like, you know, what's up with that? Wherever there's a little sticky wheel, that's a place to attack. That's a place to load on. That's a place to go to. Because it should just be, I've read the rules in Colorado. 20 days, they're supposed to give you all the discovery. They tell you they know about Brady. They know all about Kyles versus Whitley. So, what's the problem here? And if there's any sticky wheel, I start going to it immediately. And I like to, subpoena secretaries or, the small people, start at the ankle, work at the head technique, where you start bringing up the people who are just kind of caught in the middle. Kind of well, I don't know so much. Well, why don't you come on down and tell the judge on Thursday everything you do know? Because they will try and protect the lower people who really don't know how to testify on a straight line process like they do once they get a little older, I've got to, and I'll go to these little topics. I try and organize my investigation, and prioritize it. What needs to be done quickly, what needs to, obviously if there's an alibi, you need to move to it quickly. You got to understand it. You got to develop it. You got to check out whatever the client's saying about alibi or involvement or anything else. And usually I prioritize that. And I try and set the tone for litigation, which is I'm entering and it's going to be a shit show from here on out. Just an absolute shit show. Okay. And, I'm not the only guy that's going to leave the courtroom with hurt feelings today, okay? And yes, that's what's going to happen. And the minute you want to say, it's the old whip and the velvet glove. Which one do you want? You want the whip? You want the velvet glove? You want to get along? You want to dispose this case? You want to be reasonable? Oh, no, you want to kill the guy? Well, you get the whip, okay? So it pretty much goes that way. You let them make the choice. I don't make the choice. I'm just going to do the do, all right? I got to start figuring out who interviews and for what purpose. It all depends. Always let the people who are really good at doing things do it in your case. I know I may be talking, us older white guys, I try not to be just a dogmatic asshole in the case. I have learned from coming back into the PD system. What? Yeah. Unlike you, Nat Man. But anyway, so the people that are in the system now, oh my God, they're so brilliant. They know how to work all these computer programs and everything, and they marshal so much material up that I never could have done back in the 70s or 80s because I couldn't actually type. But these guys are great. So, I pick to strength. And usually if somebody wants to do it, they seem to think they know what they're doing. I'm going to let them go. But you got to kind of organize it, okay? Structure interview sheets. I used to use these all the time. If I'm trying to figure out what's going on with my mentally ill or psychotic person, I want the interviews of the family to kind of be all the same so I can make sure I'm getting the right story. I had a guy who was killing everybody in Boulder County. He gave us a story, a very structured interview for a very good investigator. Actually, the story he told us was he had adopted his brother's life. And his brother was fine, but he got sent to the mental institution when he was 10 years old in Galena, where he was anally raped by the mentally ill people all the time, and it kind of changed the things. But, so you got to check reliability. So I like to, when I'm dealing with the family, try and structure the interview so that, you see what's really happening here. And I know this is kind of light fare, but I only got an hour. All right, I got to protect my back door, which is snitches and informants, okay? And I know, now I believe they tape everything. I believe in the jail, I'm on camera all the time. And I do litigate and attack jails constantly. I attack everything about them. I attack every guard. I attack them fabricating because they're going to fabricate anti-skipper evidence or dangerousness evidence against me. So I'm busy attacking the guards. I call them names. I accuse them of starting fights, of hiding evidence, of working for the government. And I know that it's going well if the county attorney is now part of my case all the time, representing the sheriff, right? I attack the nurses. I attack anybody who comes into contact. And I'm just trying to set it up so I know they've screwed up, and I know they're lying, and I know they're acting like doctors, and I know that they're divulging HIPAA material. I've just got to catch them, right? And once I catch them, then I'm going to ask that they be prosecuted under Title 42. And in Adams County, we've caught him. This son of a bitch. This is how stupid they are. All the judges are even stupider now. They don't know anything. Well, our judge, we have a cop killing in Thornton, and our judge was a Thornton cop and a DA, now the judge. Can't get better than that, right? And so, and these guys, they filled out a form for the HIPAA stuff for my client and his juvenile stuff and everything else. That I, officer so-and-so, want checkbox my records concerning my youthful drug treatment program in a federal institution signed by me. Why do I need them? The DA says I need them. Okay? Well, that's a crime. It's a crime you can't even mention. You can't even put it in paper where you commit a crime. So, I signed Michael Hare, one of the smartest guys I know, to break down Title 42. And we have moved for the indictment and prosecution of every one of these guys. And it's just like they can't deal with it. They just won't hear it. It was like, when do we get to hear that big whipper dipper? Can we move on to the Title 42 motion? Now we'll do some more discovery hearing. You can stop the process. You stop the process of capital prosecution by litigating everything else. And it's a good day for me when I go to court and we litigate everything. We got a whole bunch of lawyers for telephone companies and this company and city attorneys and the press and everybody else, and everybody's wanting to jam into my case because what's not discussed? My guy murdering anybody. It's a good day in court when it's never discussed your guy murdering anybody. It's great. And I'm fracturing and litigating every little piece of them. I like to litigate them. I like to prosecute innocence in my case, whatever theory of innocence I have. I like to prosecute misconduct. I'm a prosecutor, and it seems to work because things go away. I've done a lot of death cases. I've only tried about 10% of them, which is even terrible to do. But, that's where you want to be, okay? And that's how it works, okay? But on my back door, I've got to revoke his waivers. I got to revoke every little thing. I've got to get it served correctly. You just can't send it to the DA because that's the dead hole. And then you got the backside. Well, the sheriff, I never got it. So we just got all this material and we just gave it up. And now we got a big problem. I serve everybody. One of the concepts of capital litigation is serving. Giving it to the DA, you might as well just, put it on your car and drive away from the jail, all right? And let it blow out in the wind, because it goes nowhere. You got to serve and engage the testifiers. I don't ask the DA to test. I will ask the DA to test certain evidence, but I also demand of the person who did the testing, CBI, the lead sheriff. You've got to engage, because when you're going to cross-examine about being a lazy or only caring about a theory of prosecution, not a theory of innocence or a theory of investigation, you got to have a witness. So you've always got to connect, and I serve them, and I get receipts. But on the backside, the waivers and privileges have to be done, because I'm just hoping they violate it. That's all. Because if they violate a waiver or privilege or reconnect, then I've got a whole big section of litigation called not killing people ready ahead of me. I'm just chumming lines. I got chum lines out to try and drag them in and litigate other stuff. So just think of it as straight line tuna fishing. I think it's the best visual I can give you. All right, I got to shut down the family, get them to not talk. I have to obtain waivers from the family. It's a pretty critical aspect of how fast and good you are. My investigators never go talk to the family without full HIPAA waivers and waivers for them. Not for your client, for them. Because I kind of think maybe the problem's there, And they'll shut you down after they start realizing, wait a minute, I'm not going to be the bad guy in this case. So if you get waivers, you got to always have waivers. I'm sure you know this. I'm reiterating this, but you get them from the family, and then you execute them immediately. You move quickly. You don't sit on waivers from the family. You go immediately. That would be a priority one on organizing investigation and mitigation phase. Priority one. All right, and I got to keep cop agents away from my my client and the jail med people, I start telling them, they say, we run the jail. I say, yes, but I run my client. And so letters go out, demands go out. I don't want them seeing the jail person. They can only see the jail person, kind of like Tammy, if in fact you think he's insane. If you think Holmes is insane, well then send him away. Send him away. I don't need you treating Mr. Holmes. If you think he's insane, send him away. And it worked, all right? Also, I have a snitch technique for my client. I tell him, everybody who talks to you is an informant. And if you're going to sit down with your buddy, and the minute they come in, anybody comes up to you, you tell them very loudly, because I want to hear this on the tape-recorded conversation. I want to hear this. You start out every conversation with, "Get away from me, you fucking snitch." It works. That's a good introduction. I mean, it's just, that's all I've got, okay? But it starts there, and, and everything else seems like, well, didn't he tell you to keep away from him? You are a fucking snitch, right? So there you go. That's all I got. Not a lot. All right. I started assessing the initial factual concerns, mainly alibi or active psychosis or, something that's, that I have to move on, okay? I start assessing the initial mental health substance concerns, mainly because I don't want the jail treating him. I don't want the jail medicating him. And that all goes back to waivers to the family. I did the protect from snitches. And, I start being real about their situation. I don't start out with, "Why'd you do it, buddy? Damn, that sounds terrible. Now, what'd you do with the little gal?" Unless she's missing, and then I gotta know. But, I'm just, I'm like, I just start reading the discovery with them. I try and just feel out who they are. I'm not so worried about the case itself. Let's figure that out as it goes on, because it takes me a long time to figure it out. Just a shoot scene takes me a long time. So, I kind of want to know. If they want to tell me a little bit about it, I take it, but I don't. It's not that much what I do, all right? But mainly what I want to do is get them ready to make them believe in me, that I really have their best interests. I really want to hear what their side is. I really want to know what's going on with them. And, but I don't lie to them. It's like, I've had clients, "Well, tell me, Wymore, you think I'm innocent?" And I'm like, I really, it's not my job, man. I mean, they want to push you to that believability sense. And, I don't lie to them, but I go, why don't we just check out and see what the evidence says, Because when the window opens, let's face it, capital litigation is when the window opens, where after you've done all this crap and attack and fight and, and carry on and accuse people of misconduct and accuse the judge and everything else. When the window opens up, they got to go through. That's the game, right? The game is getting them through the window. All right, so gain control. So I got to know my local rules by heart and all the cases. Luckily, when you've been practicing 40 years like I am, you have a lot of your cases in it, But, they all make it up. I know what the rules are. No, they don't. I'm going to tell you, judges right now they've never heard of Cowles versus Whitley. They have really a very vague understanding of Brady. And it's bad, like Scott says. This is a bad understanding. But, production pre-trial and demand pre-trial is a whole lot different than trying to rebuild it on habeas. And I know constitutionality, and I plead everything constitutionality, all right? I file my demand at first appearance. I don't care what the rules say. I know. I've had little monikers for that, but, they don't really apply to me. I'm just going to go do whatever I want in terms of advocacy and in terms of getting discovery and in terms of finding out, okay? I don't care. I've really lost any care of what people think about me. And that's a step. Once you cross that step, you really become a freed lawyer, right? You really understand advocacy and not self-concern. I file my demand. I'm going to show you that. Because my demand, it's called a demand for the protection of reliability in the case. And we used to file them separate. And it'd be like for being on the evidence and these other things. But now it's like a 15-page motion where it covers virtually every piece of discovery, and we constitutionalize it, and I just walk in and file it, and I serve it, and I serve it, and I serve it. I serve it on the cops, I serve it on the DA, serve it on the judge, serve it on the investigative function. I serve it on everybody I can. Everybody's got their own individual copy. Does everybody have their own individual copy of my motion for demand for liability and fundamental fairness in the case? Are you missing one, sir? Here, there you go. Got one too. I suggest reading it and complying with it, okay? But it's like I get the poo-poo. We know all this. Now, they give the full poo-poo. And I don't really care if anybody ever actually rules on it. I'll push them to rule on it, but it's the demand that constitutionalizes it. It's the demand that makes it relevant when they don't turn it over, which then becomes a recusal, right? I'm going for, you said you knew what you're talking about and you fully comply, so everything is intentional on their behalf once you file the demand. It's intentional. It's not just, we forgot or we didn't know. I've filed a motion to be prosecuted by lawyers that actually understand the law, by judges that actually understand and can comply with the constitutional mandates of capital litigation. All right. Be specific that notes are a very weird thing anymore because they don't actually take them, I guess. They type them in on things, preserving all sorts of their telephones, interdicting their every aspect of a police officer or a detective's technological stuff is kind of cool now. I mean, it's way different than just taking notes and then they destroy the notes. It's like, wasn't the notes the best accurate, But just entry logs, everything else. And discover everything the jail is keeping on your client. And I put tour, okay, that's because I'm from the 50s and I sometimes misspell things, okay? All right, and I'll kind of show you where we go. Now, it used to be duplicates of photos, but now, it's different now. I mean, I'm just learning this, on the photos of a crime scene where they're going to run them into a Faro program and make this computer generation of why your guy's guilty and how it happened that juries love to look at. They'll take photos, or they'll take them in TIFF, right? And they'll produce them to you in JPEG. And you're like looking at it and you're going, well, wait a minute. Well, I want the TIFF photos. Well, the DA will say, well, I got them in JPEG. And I go, I don't give a shit what you got them in. I want them in TIFF. And we just have a big problem there too. So now just understanding the formats of what's actually taken, understanding and getting the raw information, understanding and getting what they actually have, because they know what they have. They just don't want you to know what you have. So it's all very complicated, but it's all very ripe for litigation, right? Cars, movable things, get to them, inspect them. Because, on the movement of the crime scene, the movement of the physical evidence, I try and, I don't know, is the word interdict, intersect, get into, stop, look at, test, I try and jump on it as fast as possible. Cars that are being left out in the open and they got blood in them or broken glass where bullet holes are going through them, the glass falls down. Everything means everything to me. I just want to try and get in as fast as possible or be prevented from it to where I have later claims. I don't know where the claims are going to go. I'm just trying to lay the ground and then find out what's screwed up and then litigate it later. Houseless crime scenes, I want to get to them. I want to bring an expert. If you can go into a crime scene, I've been to thousands. And, maybe not thousands, lots of hundreds, maybe not even that many. But at the same time, each one had a great impact on me. But, when you go into these things, you're like looking around and you're seeing things. I've found some crazy things in there that help me win cases. I found a cufflink that disappears in the picture. But when I go in, if you can walk in it, you can film it. And now with 3D photography and all this other stuff, you can walk in with that. You can start scanning the damn thing. You just hire for $10,000, you can get a lot of bang out of a crime scene investigation if you bring in the right technology. And that's not a 35 millimeter camera. I mean, it's like super crime scene stuff where you can go back, relook, and understand every little piece about it. You don't have to sit around and guess angles or get the protractor out or try and line up the pictures anymore. So I'm just telling you, if you get into the scene, go big. Bring a lot of stuff. Get a van out there. All right. If they're producing evidence on a reliable basis, if they're a company that produces like, I like kind of to separate them. I like the investigative people that are just going to do the photography and everything else like that. I don't necessarily want them to be involved. I will bring a gun guy separate to look at it separately who doesn't involve himself on that. That's a whole nother lecture. Why are you interrupting this? Okay, and then trace evidence. I feel very pressed. Okay, I want trace evidence. I want it, and I want it now. I got to move quickly on trace evidence, which is, are you done testing it? If you're not done testing it, why not go ahead and test it? And then if you're done testing it, give it to me right now. I want to gain possession of trace evidence because they love to sit on trace evidence. They love to say, well, we haven't finished testing it because and I'll show you this one thing. I had a triple homicide, white guy, kids are alive, mom's dead, his wife's dead, and the family's dead. And they were hiding the bullet from me. They didn't have casing, so they were going to try and do this bullet composition analysis on me. And it was back in the day when it was happening, before it was actually destroyed as bullshit, right? But, they'll try and sit on it. And so just you getting after it. I'm not very strategical. I don't know how they're going to try and ambush me. I don't know where they're going to try and ambush me. So I might as well just go out and try and get everything. I believe the more I know about the case, the better I am to win the case, as opposed to hiding from knowledge. I always say there's the no boys and the go boys. The no boys are, I didn't do that, and I didn't look at that, and I didn't look at that, and I didn't look at that, so I'm the smartest guy alive. And then they just get hammered into death case. The strategy of not knowing anything is really just not very good strategy because it shows up on the 35C. So it's better to know everything and then make a decision. What's that? Oh, do I? Well, I got 50 minutes worth of shit. All right. Gerald, at any rate, okay, so prosecute your case. I prosecute physical evidence, okay? Instead of defend it, I try and move into a mental state of, is there something in the physical evidence that says not guilty? Is there something in the physical evidence that says reduced culpability? Is there something in the physical evidence that says alternative suspect? And jurors, they like physical evidence. They like physical evidence. And I believe every case is a physical evidence case. There's something there that's either going to tell a different story. And in the world of, if you ever sat on a criminal case as a juror, you'd probably think, oh my God, what a pack of liars. You're picking from a pack of liars, and then you have a piece of physical evidence. Physical evidence can enhance the reliability of your narrative. Physical evidence can destroy the reliability of their narrative, right? By their narrative, what I mean is when the prosecutors sit around and make up a theory about why you did it and how come you're guilty, right? All right. So I'm going to access it, which I do early on. And I'm going to tell you right away, I start pushing to access the physical evidence. I want to know what's there. I want to know what condition it is now. I want to know who's seen it. I want to know who's touched it. I want to know why they picked it up. I want to know what they've done with it. Because they will only test their narrative. And if they're not testing other items, then there has to be, then why'd you pick it up? And how did you exclude it as being part of, a cop picked it up. So why is it now excluded? Why is it not tested? And then I'm going to mess with them on that. I'm going to start baiting them to test it, right? Or is it a lot of times it just goes away. When you get an envelope that says it's supposed to have 3 hairs and a piece of skin in it, and you go and the envelope's empty, that's a big day. There's going to be, we're going to have a party on that, right? There's going to be missing hair and skin party. And everybody's involved in it is going to have an opportunity to come down to the courthouse and lie about it, right? And it's just going to be fun. Better than litigating your guy removing the hair and the scalp. All right, so, and now with the photography, it's phenomenal. I mean, I'm going to tell you back in the day, and I don't want to war story it too much, but back in the day, we'd be going through the evidence stuff. We would have to take a 35 millimeter picture. We'd have to write down by hand all the chain of custody stuff. And now with the photography and the amount of photographs you can take, it's just simply, turn it over, take a picture, pull it out, take a picture, take another picture. You don't even have to even touch this stuff. And then you can go back home and obsess about it later and then start figuring out what's going on. And, and not only that, it sets the tone of what physical evidence is there. I had an exoneration case where a kid was 15 years old, accused of murdering a woman, excising parts of her body in a surgical way. And they ramrodded this kid and convicted him. And so it was an old case, but I had to know what evidence they still had. So I go and take a picture of all the evidence, and I build a chart with all the evidence. And then every time we'd go to a hearing, this son of a bitch cop would come up with another piece of evidence. And I'm like, Barry, where was that from? We'd go through the list. Well, it wasn't there on June 27th, 2004. So I begin to realize, which I believe is true, take this as a truism, not factually proved, that cops have squirrel holes of evidence. How do I know that now? They have it in my case right now. I mean, they got pieces of limbs, where they cut out limbs. They got charts they made. These detectives keep shit in their office that's physical evidence. They'll keep statements. They have squirrel holes. And, I'm like, it's happening to me again 20 years later. I'm like, what in the world? And then the fight about how it doesn't get in there. But you got to realize it's not just over in property. That's crazy. They have squirrel holes where they keep their own shit. They keep their own lineups that they showed the guy. They keep everything. It's just like a warning, okay? So how aggressive you are and how much you deal with each potential person separately, each potential cop separately, and you analyze and attack them and connect them to the case separately, then stuff starts coming out. And it's always about the reliability, and it's always about motion to recuse. It's always about a motion to strike the death penalty because of fundamental unfairness, all right? I demand my expert presence before any alteration to any piece of evidence. Now, they alter evidence all the time in the testing process. And if you're a bullet and gun guy, which in America, you got to be a bullet and gun guy, before they will test fire bullets or casings or examine them for just, extraction marks or extractor marks, or they will run an acid solution on them, which takes fingerprints off. And so everything matters. Everything matters. And I just want to know, did you do it or didn't you do it? Did you alter it? Didn't you alter it? Because, if you ran boric acid over the casings before I got a chance to get in there and I asked that you not do that, I'm going to accuse you of destructive testing and that you did it purposefully, that it wasn't a mistake because you're a hell of an expert. You can't be stupid. You're just a lying, cheating sons of a bitch, right? So that's, there's two options. All right, so I'm going to intersect the experts for the DA. I send them letters requesting their background and expertise. Why rely on the DA? They're so lazy. They're not going to do it, and they're not going to testify. The DAs don't testify, but these guys do. So, I pretend like they're just helpful guys and gals. I like to get over to the office and run around there, give them stuff, ask them stuff, send them stuff, for them to read. I offered to come over and copy it and pay for it. Well, no problem. I requested them independently to be president for testing. Hey, I know, the DA says, well, okay, so DA says yes, no. The DA says no. Which DA said no? That I can't be there? The DA says no. Do you have the name of the DA who said no? Because I haven't got the no. Just jamming up their little game, I tell them to test other stuff, which I love doing, which they just say no. They just no. And they'll say, can I have it? And then they say no. And that's a nice piece for a jury. That's a nice piece for a jury. If you have one juror who's like, wait a minute, I got a pack of liars, and this guy wanted that tested, and they won't test it, and he asked you, and you wouldn't do it. I mean, it's a good piece, right? It's better than just the story of guilt. I demand an explanation. Why not? Who told them not to? I send them interrogatories. Yes, I do. And to give them a name, I know that's not I know interrogatories are not part of criminal discovery. I know that if you had a backed up toilet battle, you'd get way more discovery than you did on a capital case. But I've never read where it says you can't send it, okay? So I need affirmative no from the Supreme Court or World Court before I won't do something. So I will send them certified letters of inquiry. And it says certified letter of inquiry, and then I'll ask them, and I'll send it to them. I had a lot, cop shootings and big murders and stuff like that. They really gang up together. We're not telling him nothing. And so then I send them these certified letters of inquiry, and even if they're federal officers. Well, I'm a federal officer. Okay. When you come down, you can tell them all about how you're a federal officer and you didn't respond to my goddamn certified letter of inquiry. Okay? Because it just asks them questions. Did you do anything? Did you find anything? Did you tell anybody? Do you have any material? Because I just want you to look like a goddamn liar like you are, right? So inventive civil practice and I like, you get your embosser, boom, you hit it with embosser. So, they like to rub stuff, send it off to them. And then, I know, it's pathetic, isn't it? It works. It works. Then I moved to strike them for lying, cheating, and just being lying, cheating, evidence withholding, sons of the bitches. Because I, like everybody, I'm always trying to figure out how do I get every goddamn person on the stand for something, pretrial. Because they hate it, right? And all these discovery motions and all this other crazy stuff kinds of work. So this, it's a little primer. All right, I got to organize. Now I'm doing all this pretty damn quick because I'm organized to begin with. I have my motion practice ready to go. I have my demands ready to go. I've organized who's involved, who's not involved, who looks like they're going to be a worker or a experter or something else. You can get, the cops that are, the one-time hitters on the cops. I mean, who's developing the case for them? I really want to intersect them. I really want to, get into their shit and get all about that stuff pretty quick. So, we organize motion indexes. This is wild back in the 70s, but now it's pretty much automatic. And you can see, and I can watch the flow. Okay, I've made a demand. They've made a response. I want to up the ante. I want to now start moving deeper into them. I'm going to do another motion. I always do a call, a letter, a motion for sanctions, a demand, and then a motion to strike, and then motion for recusal. Am I hitting every piece? Am I all over the bullet? Am I all over the car? Am I all over the mental health? Am I all over the jail? Have I identified the people in the jail that need to be visiting with me in the courtroom? Who's the asshole? Let's cook that guy good. Let's go there. And where can I start? Can I bring up the most vulnerable person in his whole little parade and start with them? The clerk, the custodian, let's start with them. Bring them out first, okay, so that you can get all worked up. All right, so my discovery index is incredibly important. When you got stuff, when it was produced, who was it produced by. You got to keep it one person. And in my capital case, one person would get, one person gets stuff from the prosecution. One person gets mitigation, independently developed material. I keep it separate so I understand what's going on. Photos, I've won a lot of cases just on photos because they got them out of order or they're not showing the right ones. And I go to each piece of physical evidence. I have to know when I go to trial, I don't let somebody come in and lay a foundation on any piece of evidence from just, they found this at the scene. No. Did you find it at the scene? No. So you really don't know. They'll try and bring in the lieutenant or somebody. I make them prove each and every step of the physical evidence. I don't ever waive a foundational basis because not everybody's as good a liar as the lieutenant or the sergeant or the investigator, okay? But you gotta know. You gotta know where it went, where it came from, who picked it up, what happened to it, when it got logged in, who logged it out, who took it somewhere, what did they do with it? Because if you're gonna try and jump a piece of the chain of custody on me, I'm gonna say, well, wait, didn't they, what'd they do with it there? Didn't they destroy it there? Didn't they change it there? Didn't they hide or take a piece out? And it jams up their narrative, all right? But I have to know, so every piece of physical evidence, it's gonna be a piece of physical evidence, it's gonna have its entire chain, instantly. So when I go up there and they're dealing with a piece of evidence, boom, I hit the button, there it is. I know exactly how it's changed. I know if it had a pickup number, like the sheriff's officer number, tablet number 4, became property log number CR4R12 up to CBI number to FBI number, back to exhibit number. And when I'm making a record on the evidence in the trial, I make the record on I do it all the way through. You're talking about placard 4, CBI number, bookend number, that number, right? It's just a discipline. So that if ever you have to have a habeas person looking at your case, they understand what piece of evidence you're looking at, right? It's kind of an obligation to the appellate people. All right. But here's kind of the thought process I'm going in my first couple months into the case. I'm trying to get them to commit to an interpretation of the physical evidence before I'm going to commit, right? The game that's played is they want you to commit first to what means what. And I'm never going to commit. My expert will never, ever render an opinion on a piece of physical evidence or a theory of the physical evidence or a theory of what transpired unless they are absolutely assured they have every piece of discovery and the opinions of the prosecution experts. Because I'm looking for two things. I'm looking, is there our interpretation of the evidence, and is their interpretation of the evidence correct? Judge, what's their interpret? We're just checking their work. So we have to know what their work is in order to check their work, okay? That's why we need their opinion well in advance. That's why, and if they're saying, I can't come to an opinion yet, I go, well, what day can you? What else do you need? What they're waiting for is me. What they're waiting for me is my interpretation of it so they can come in and say, that's not it. Oh, he's wrong. I have the secret piece of evidence, right? And that's how they destroy your experts at trial. So I'm pushing them to commit to their theory of interpretation of physical evidence. Hard. Because then I got something. I can't begin to investigate my case with expert insistence until I have all their interpretation, their foundation, their background, right? Everything, I need everything, Judge. I can't start. Well, I can't start. And I litigate the physical evidence better than litigating the facts of guilt. That's a run theory. I've told you this. I'm the pain in the ass, so make me go away that you can pick on a get-along guy's client. Everything to me is a big deal. I enjoy making mountains out of molehills. Why not? I demand, I motion, I SDT, I have a hearing with sanction, I move to recuse. I execute the plan. It's not like, when you make a motion, when you make a demand on the prosecution, if you don't have a consequence to it, If you don't have a time for it, well, it's not going to happen. Did you ask for that? Yeah, I asked. Well, did you demand a date where it's going to be produced? No. And if you demanded a date for it was going to be produced and they didn't produce it, did you have a sanction motion? You got to prosecute anything you file or demand. You can't just let it sit there. You have to prosecute it to its end, and its end is production or not. Every little piece, like Scott's telling you, every little piece. It's got to finish. Just demands out in the world. Oh, I got them out there. No one gives a shit. And you know what else? It's not going to save your client's life. In capital litigation, there's a short game and the long game. I'm going to try it to get him life or to win it. But I'm also got to make sure me and him aren't sitting in a gas chamber or a someplace else. So you've got to long game it too. And this is a lot of a long game protection, right? Things change, people come forward, you never know. But, like I said, demand without sanction, you might as well put it on the top of the car, drive away from the jail, just let it float out in the air, okay? Because that's about what it's worth. All right, be a constitutional lawyer. Don't go to hearings of consequence unless you know everything the cops and the DAs know. Which is called preliminary hearing. You don't know shit. It's amazing. I go, well, Judge, I'd like the district attorney to tell me right now he has given me everything that's required under Rule 16, Brady, Cowles versus Whitley. Well, I've given them. No. I know you. I know. See, they'll say, well, I've given them all I got. Well, the problem is you don't give a shit. Or you don't have anything. I don't care whether he has anything in his file or not. He hasn't affected his constitutional obligation of production. And that's what I want to hear about. And so I moved to continue the preliminary hearing because, Judge, what am I supposed to do? Just guess? The preliminary hearing is a hearing of constitutional consequence. Your right to have a lawyer there. If you have a right to have a lawyer there, your right to have an effective lawyer there. And the mechanism is laid out in the rules of discovery and state law and constitutional law. So you're not, Judge, I'm just the pretend lawyer. And I don't do pretend lawyer. So I'm either going to continue the hearing or we're going to start having battles over discovery right now, right? So it's just a little rule of thumb. I don't go to a preliminary hearing unless I feel, well, let's face it, unless I'm thoroughly lied to about having full production. And then if in fact I catch you lying, then there's consequence, right? I like to consequence everything they say. And consequence is move to strike them, consequence of perjury, alleged pejorious action, doing it all the time. Our new cases, we got 5, 10 motions of prosecutorial misconduct, perjury, lying, misrepresentation, hiding evidence, violating CFRs. It's amazing. I was telling Tammy, from hearing what Scott was saying, we've got whoppers in there that they won't even deal with. They just won't even deal with. Okay, you don't want to deal with it? Fine. But that's long game, right? Someone's going to deal with it, hopefully, someday. I set time periods for compliance. Okay, Judge, we'll comply with that. Okay, when? When? We'll be over there tomorrow. Next day? What day and where, Judge? You got to set compliance. Litigate non-compliance. Keep upping the ante. Who's Mr. Prosecutor, evidently you can't get shit done, so can I help? Who's in the way? What can we do? Let's get some subpoenas on him. And the CCJRA or Criminal Records Act, it flows at the same time. Demand, CCJRA, everything. All right, things to do at the preliminary hearing. Continue because they haven't provided all the discovery. That's number one. I do it all the time. And it starts making people nervous. I SDT the pieces of evidence that are being withheld. I've requested or had the hat. If there's a hat in the house that they say has a lot of GSR on it, or it doesn't have GSR, or is located, or it has a color or a vision of it, I try and get it into the courtroom and then move it into evidence as an exhibit, and then the stenographer or the court clerk becomes the custodian of it. It makes it for a different way to deal with the evidence. You get more examination time. She's not going to sit out there, or he's not going to sit out there and watch you examine it. It's a trick, okay? I mean, and I don't do it a lot, but if there's a piece of evidence that I'm being kept from, I SDT it to the hearing. And we're going to have a fight about it, right? So at least we have a fight about the evidence that's not being given to me. And sometimes it just walks up there. There you go. There it is. Geez, I've been trying to see that for 2 months. Now it's sitting right there. Thank you for bringing that. Begin to commit prosecution to theories of physical evidence. So the preliminary hearings to me is very open-ended. And I just want them to tell me the worst story they can about why my guy's guilty. You know, anything else? Got some other secret stuff? You know, you try and develop the worst story. Has anybody had a murder case not bound over in the last 50 years? Just what I thought. I mean, you got one not bound over? Good for you. That's an abnormality, okay? Just one, or do you hit them all the time? You're just batting 1,000 on those? All right, so I've never had one. Nobody I've ever seen had one. You had one? No. And so were you representing the Pope? Yeah, okay. All right, so I like to, don't close down at the preliminary hearing. Use it for an expansive, I try and hear the worst story anybody's got. And they want to tell you because they're all flamed up, right? At the preliminary hearing, everybody's really flamed up. So, and I like it on the record, just as much as you can go slowly through physical evidence and observations and, when did that happen? And it doesn't sound like you're really trying to defend your client much, but you are building a great record, okay? So, 60 to 90 days out, I like to finish rounding up all the discovery, understand what's not coming, what's going to be a fight about. I like to structure my motion practice to resolve production issues so that I can begin to structure that as a reason not to have the preliminary hearing prior to time of full discovery. I'll structure motion practice to determine all hearsay. I tell you what, I don't know how many people are doing life or on death row from the observations of the friends of the dead person where they're just, well, he didn't look normal afterwards. He wouldn't talk to me. We went out to dinner and he didn't cry enough for me. Like, what the fuck is that? Or I was like, oh, well, okay. Well, I actually did this in one trial. Well, he didn't really like you, did he? You're kind of a pain in the ass. So, aren't you an obnoxious person who's getting everybody's business all the time? But that kind of hearsay evidence, that kind of expert evidence of how you're supposed to behave, or your behavior is somewhat different. That's expert opinion, or that's hearsay statements of what somebody else said. And the hearsay just rolls into your case all the time. And it's objection hearsay, and res justi, overruled, proceed. Okay? I file a motion, and we just filed one, where I want them to designate every piece of hearsay they intend to introduce. Because then I can begin to litigate the admissibility of that piece of hearsay individually. Other acts, and not just bad acts, but any act. Not being a good person at the dinner. You got dead wife. You're going to go out and consult with her girlfriends or her family members. Bad idea, you guys. If you you're ever accused of killing your wife or being part of involvement of Liz, don't go out with the family. Don't go out with the friends, okay? It's going to come back bad, all right? But, just that's another act. That's some act indicating guilt, and so I want to be able to litigate it. Lay opinion, deadly stuff, expert opinion. I move to strike them all if they won't produce them, all right? We have an omnibus hearing in Colorado. The omnibus hearing, no one ever used it. It's a dicey thing to use. You got to know when to use it. But it basically, if you're having trouble setting time periods of production and everything else, or you can ask for an omnibus hearing. You ask just for a resolution hearing as to when and if they're going to produce material. Because my position is, well, we can't get going on our experts or our investigation until we have it all. And so now I'm organized. I know where my evidence is. I know what hasn't been tested. I know which opinions haven't been gone forward. I know which items may have impact in it. I know who's struggling. And so I try and set an omnibus hearing under Rule 16 in order to have the judge get involved in setting time periods, right? And I start bringing up complaint after complaint after complaint. And supposedly at the omnibus hearing, he's supposed to set time periods and production dates. Because it's always consequence, isn't it? In capital litigation and discovery, isn't it always the problem is consequence, that they keep deflecting consequence or not attaching consequence? Okay, so you can see what I do with that. All right, so 100 days out. You should have the evidence organized and know what it means. You should know what's missing or weird. Weird means just weird. What happened? Weird. Like we're going to go out and talk to some guy about the stab wounds on the body in the field, and you have this, and then you never have the report. Okay? Well, something happened. They went out and talked, and it was bad, and they didn't write it down, and so you need to go there, right? That is stuff they're still hiding. Witnesses who won't talk or are funky need a directed motion or attention somehow. Because, I just got to figure out what's everybody going to say. Okay, you're about to ready to figure out your defense that will not be contradicted by the physical facts or convenient cop or expert testimony. Because don't forget, they have 1 million cops ready to testify that in their experience, whatever you say about the physical evidence really isn't it. And this guy will just come winging in, and it'll be rebuttal, you'll never know. All right? Let's see what else I got going here. Natman, what's my time period? What? 15 minutes. 18 minutes. Okay, so this is the motion to protect reliability. Okay? Now, and then I have the Palomo motion index. And these are materials I gave to you guys. Did you put those on there, Gerald? You don't know? All right. Organizing physical evidence chart. Evidence tracking example, forensic experts, just a theory on that. The Garner motion chart, and the Garner motion chart is for me to show you how it took me 26 motions to find out what was going on with the bullet composition evidence in that case. All right, so what I'm going to drop, motion to protect reliability. And this is my motion to protect reliability. And it basically goes through, and you can see how we structure it, maybe not, but I will dump this off on the file drive for you guys to have if you don't have. Did you guys get this on your materials? You didn't get so he put the PowerPoint on, but he didn't put my file with it. Okay, not a problem. All right, so here we go. We go through demanding everything. We in our appearance, we're going to waive. We go through waiver. Notes, tapes, everything going on. We basically demand all physical act. We demand presence, interdiction, testing ability, waivers of rights and privileges, assertions of rights and privileges in the jail. And I find this to be a very helpful setting the table kind of motion, all right? So just when you get your material, this is what this is. We call it the motion to protect reliability and fundamental fairness in a capital case. Okay? It's constitutionalized, so you don't have to do that. It's particularized to Constitution. We plead it rule. We plead rule. We plead Colorado law, Colorado Constitution. We plead federal Constitution. So every pleading, you'll see how we constitutionalize every particular thing, which I'm sure you guys are doing, but it's just rip me off. If it's helpful, use it, okay? That's right here, revocation of all releases and waivers and assertion of all rights and privileges. It's kind of in there. That's the demand. I've told you I also execute it by way of service on them and service of waiver on anybody I can find out, especially the juvenile probation people, all these other little compliers, okay? So let me move out of this one. That's the waiver, all right? This I got, next thing I was talking to you about, physical evidence viewing. just how we go, just what it kind of looks like to me. You know, these were footprints in the Tim Masters case, which was an exoneration we did. That's where actually we got these great people to do touch DNA, and I know Cutter's here, and it's just, but you know, the physical evidence said he didn't do it. So these are footprints, you know, that were there, that weren't my clients. You know, I'm just photographing the packages of everything. And amazingly, I go talk to the lawyers who tried this case, and they tell me, I could never figure out the footprints. What do you mean you can't figure out? I can figure out which one was which. We just didn't do it. I mean, come on, there's footprints your client doesn't have right along the drag line of the body, all right? But it was, you know, that's number one, and that's what number one looks like on the underneath. And you know, studying it at the place doesn't help me, but I can see a pattern in the shoe impression on the plaster, right? And so, you know, every little piece gets photographed. Every little piece, number one, gets its own little file. It has its own little file as to who got it, who logged it in, who logged it out, and every photograph that attaches to it, including the FBI. So when I'm going to deal with this piece of evidence, I got it all. And if something's been added or taken out of evidence, when I go to hearing, I'll know. All right? You got to kind of update these things too. So maybe this is helpful, maybe it's not, but it just shows you a piece of evidence in this case. All right? Then we have. Oh boy, where'd it go? Did it go away? It went away. It's on the left side? Where? I got it. See, the problem is I can't see this. All right, okay, here we go. Physical evidence charts, just a quick look at those. So I'm going to figure out what they think they have in evidence. You know, I go through, I make a little chart, what they think JT1 is, and a little summary of what they got going, just a working summary. JT2, a sliced soda can, negative for body fluids, hairs and fibers, no latent prints. I'm trying to understand now what I need to deal with. So, you know, after I've got to look at the evidence, I understand what it is, now I know what it is, what's happened to it. It's my cheat sheet for working on it. This is what I'm trying to understand. This is just I put this in because it's kind of a cheat sheet for you, because when I leave, it's called Discovering Litigating Physical Evidence in Criminal Cases. It used to be a smaller presentation I did on how I organize it. You can see organizing the physical evidence from evidence tracking, from scene cops, detectives, techniques. This is just a conceptual basis of how you ought to organize every little piece of evidence. Location, data recovery. It just makes you a more fluid and intelligent lawyer when you're cross-examining and you're moving forward. And this goes on, and I will dump this off for you. And, you know, kind of where I want to finish up on here is a little thing I did years ago after a Garner case. So this guy, he's supposedly moving that night, and while he's in the process of moving from one house to another house, his family gets murdered, but not the kids. And they had the gunshots. You could hear a gunshot, and then you hear dun, 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 and then you hear more gunshots. And this was 98, 9, 4, 6, somewhere around there. And so we were limited in a lot of our technology, but the issue was they couldn't pin the gun to him. They thought he had a Walther PPK 380. They couldn't find the gun. There was a rumor of having a gun back when his father died. They couldn't find the gun. They had bullets and no shell casings. Well, they did have shell casings, but they're still trying to relate it back to a gun. So they went, searched his house, searched his trailer, searched his mom's house, and they found some bullets. And this is bullet composition evidence, which is no longer valid, right? I mean, it's just not, you can't say the bullet from this particular body or batch came from like another federal, okay? And they were trying to say, they had this theory that the way they made bullets was they went and got like scrap metal or radiators, and they mixed it up. And then so all the lead was unique. So if the lead had the components of tin and zimuth and all these other things in one place, and that bullet, then it's a match, and it matched the bullet, and people went to prison and got the death penalty on that. So anyways, we go in and we're looking, I'm doing my normal due diligence, and I see this bullet casing with the FBI name on it. And so we start attacking it right away. And also one thing I did on it was I subpoenaed all the cops to bring all their photographs at every hearing, all the time. And two things significant happened in this case. First of all, I kept the bullet evidence out, but it took me 26 motions. It took me a constant attack on produce it. Then they throw up everything. Like the greatest argument right now that I found to be the most seminal, important argument that seems to trump everything on constitutional law, trumps discovery law, trumps, the writ of bull. It's called the copyright law. Okay, because I'm trying to get into Faro program, and we say, well, could you give us a copy of the program to see your measurements of this cop shooting scene where they're, death penalty by cop. I don't know if it's happening in your neighborhood, but it certainly is in Colorado. If a black man runs, you must shoot at him as much as possible. And then if you miss him and he falls down and shoots you, that's called the death penalty, right? But you're trying to give him that active death penalty, and your bullets are going everywhere. And sometimes they yell, hands up, as they're banging away at you. So anyway, I'm trying to find the Faro program. I'm trying to find out their values, because they're making these, have you ever guys heard about the Faro program? It's just horrible. Faro sells a computer program that lets local idiots tag in little measurements, and it creates a video of your guy murdering the cop, okay? So we're like, well, can we see, can we just see the program? Oh, no, Judge, that's copyrighted. Oh, boy. Oh, no, you can buy, so the judge says you can buy your own program. I said, well, the legislature hasn't given us the $9,000 budget item, so why don't we just go back to discovery, right? So copyright law seems to be a big problem. And they ran copyright law, and they ran copyright obfuscations on us on figuring out this whole bullet. Like, how many bullets does Federal make, and where do they make them from? And it turns out they buy them from giant blocks of metal that are quality controlled. All right, so that's where it came down. But it took 26 motions. And what you're going to see on this is kind of my walk on the motions, the Garner motion chart. Just to give you an example, I mean, this is pursuing, this is going to be a variation of Scott on his snitches and his telephone stuff. It just goes and starts breaking down all the motions that we constantly had to build with. Was production, demand, and in 4 minutes or less, I'm kind of going through these, but you can see, and I've just got them captioned, and I actually have the motions on here. And the other part of that, but it took me 26 goddamn motions, to get that stuff excluded, all right? And I'm just telling you, it's just a walk. And then the other thing that happened, and cops take pictures on their cell phones. Back then, they'd walk into a crime scene and bust off their cameras with Polaroids, right? And like I said, every cop's got their own squirrel hole. So I'm running the preliminary hearing. At the preliminary hearing, they had created the sketch and the photographs of the crime scene. And you'll see this on derailing the physical evidence PowerPoint I have on this material. What it is that they had created a picture of Dad laying on the couch, and I got those photographs in there, and the cover's this certain way, and he's got a bullet wound, and Mom's gone, and the whole crime scene has been photographed and presented, and they have sketches and diagrams ready to go. And this cop comes in, and he hands me a set of Polaroids, of which basically shows the bed totally torn apart. It's got medical people attending to him. You got swabs and dabs and medical debris all over the place. And so what was pretty obvious was that somebody had recreated the scene, right? Now, I asked every cop, every person who testified, did you recreate that scene? No. Help me out how this crime scene, your little poster up there, became not this, but that. No. Who can help me out? And they kept referring the next guy up, or maybe that, I call that guy, he couldn't help me out. And the jury walked that guy. Basically because everybody lied about the crime scene. That's just all I got to tell you. You never know where it's going to come from. Thank you for bearing with me. I'm about ready to collapse. No questions, please.